Hey guys. All right. Hey, this is Civil Rights, Civil Libs, the last unit pretty much of the year, lecture 5. So it's notes 17 and 18, all right? So we talk about voting, and then we're going to talk about discrimination in the private place, all right? So let's get into voting really quickly. The 15th Amendment, right, bans discrimination, right, on the basis of race. Therefore, the 15th Amendment says you cannot deny the right to vote on the basis of race, which is one of the Civil War amendments, right, civil rights. So what you get, though, is a response to that from the South, right, to get around that. All right, and so look at some of the responses that the South does. We have white primaries, all right? Primaries in which only white candidates can, or white people can vote, right? Or white candidates can run, all right? You have a poll tax, which essentially you had to pay to vote, right? Which is going to keep poor people from voting, in particular the poor African-American people, right? In the South. And then you also had literacy tests, right? So the effect of that was you have a huge population of former slaves who don't have the ability to read, and therefore, if they can't pass a literacy test, they can't vote. And so when you look at these white primaries, these poll taxes or literacy tests, they're based basically on not race, but some other things so they could get around the 15th Amendment. Now each of those, the literacy test and the white primaries were declared unconstitutional, and a poll tax actually, the 24th Amendment says no poll taxes, no paying for voting can occur. Now, another thing that the South tried to do to get around that are grandfather clauses. And essentially what a grandfather clause said is that if you could vote prior to the 15th Amendment, you didn't have to take literacy tests, you didn't have to pay poll taxes, right? So again, keeping African Americans from voting, or even some poor whites or illiterate whites at that time too, right? And exempted those who could vote prior to the 15th Amendment, grandfathered them in from having to take literacy tests or poll taxes, all right? Okay, so these are ways around it. And so what you get is, one, you get some things are declared unconstitutional, you get an amendment to the Constitution, and you also have the Voting Rights Act of 1965, right? The Voting Rights Act of 1965 is a huge thing. And look at the provisions within it. And I would say make a cheat sheet with these things, right? Because it's hugely important, all right? No literacy tests, right? And look at 2 and 3 and 4. It empowered federal officials to, 1, register voters to ensure citizens could vote, meaning bring armed guards down to let them vote, and federal officials could count ballots, right? Now, this is all the Voting Rights Act is really aimed at the South, which had a discrimination of obviously treating, discriminating against African Americans. Therefore, this allowed the federal government to get involved, which prior to that, voting had been very much a states' right, a reserved power, like a 10th Amendment thing, all right? Okay, so, and this is where we have all these young kids from the North going down into the summer of 65 to register African Americans to vote on the basis of the Voting Rights Act, right? To get around all these other things, barriers that the South had put up. Now, other things that were added. One thing you have to understand is the Voting Rights Act is a sunset law, which means it needs to be reauthorized or repassed at certain points, just like a regular bill. Now, and the reason for that is ideally, that the South or other places that it discriminates stop discriminating, and therefore you don't need this legislation anymore. It's been reauthorized every time, all right? It was reauthorized fairly recently, I want to say 2009, all right? And they've added amendments to it, right? Like, look at this. States had to include ballots in languages other than English if they had a significant non-English speaking voters reside in the area. Now, number 6 is the most controversial, and we have to bring this to, it's in the Supreme Court. It was in the Supreme Court this year. States that had a history of voting discrimination had to literally file with the Department of Justice to get permission to make any changes to the voting whatsoever. And the examples are, where were you going to vote? Those polling places, requirements to be a candidate, deadlines, changes of elections, even where you were going to vote. I even think like redistricting, when they redistricted congressional districts, they had to get those approved by the Justice Department to show that they weren't discriminating against, right? Or discriminating against African Americans, right? Now, in 2013, the Supreme Court heard number 6, the part of the Voting Rights Act that said that states that had discriminatory past had to clear things with the Justice Department. That was struck down this year in a 5-4 vote by the Roberts Court. So there are, I wonder if there'll be legislative reaction to that. I know that they're talking about closing, maybe early voting, maybe voting in the middle of the week, all these changes. But any changes no longer have to be cleared with the Department of Justice, in which, there are people that are concerned that does that mean then we go back to not necessarily Jim Crow, but this idea that poor African American people are not going to be able to vote because of the changes. Do you have to take a bus farther? Do you not have a car to go farther to vote? Lots of times if it's only on a Tuesday, can people get off work to vote on a Tuesday? That's why we have all this early voting and weekend voting and all that kind of stuff to get people the opportunity to vote more. Is that going to go away? All right. So the Voting Rights Act of 1965, huge, signed into legislation by Lyndon Johnson, just like the Civil Rights Act of 1964 was signed into law by Lyndon Johnson. All right. Now, the effects of the Voting Rights Act of 65. Huge increase in black turnout, large increase in number of black elected officials. And even more importantly, look at number 3, is that white elected officials had to take into account the needs of African Americans because they were voting, right? They're now your constituents, right? And so this is interesting, the example of Strom Thurmond, who had been a Dixiecrat, a Southern Democrat, had run against Harry Truman, was for segregation, right? As soon as the Voting Rights Act is passed and African Americans have the right to vote, he immediately switches gear and says, okay, you're my constituents, what do you need, right? And he is reelected all the way up. I've told you stories of Strom Thurmond until he's 94 years old, and he dies at the end of his term at 100 years old, right? So a guy who had been previously elected under Jim Crow laws was also elected when African Americans had the right to vote, right? Okay. Now some other things. Remember, we've already dealt with kind of the redistricting and majority-minority districts and racial gerrymandering. You guys know that Shaw says no racial gerrymandering. Miller v. Johnson, not to get confused with the obscenity of Miller v. California, says that race cannot be the major factor in drawing the lines. So it cannot be the factor. You're drawing lines because of race, because we know that certain demographics vote certain ways, right? So people are going to be splitting people based on demographics because they want certain votes. But if it's purely on race, it can't be the factor. All right, and that's what Miller v. Johnson says. All right, so that's pretty straightforward, the voting. Let's move over to this idea of private discrimination. Okay, so everything we've looked at in the 5th and 14th Amendments, no state shall deny any person life, liberty, or property without due process of law. That protected people against discrimination, gender, race, sexual orientation, etc., from the government. All right, but what about private businesses? Because we've been looking at schools and things like that. And so here's what we get. Congress has the power to regulate commerce, right? Let's make sure we understand that. Congress also has the power to tax and spend, right? So instead of them using due process, instead of them using that, they're going to use their power, their commerce powers, and their power to tax and spend. So now, going way back, 1866, we have the Civil Rights Act of 1866, which says no discrimination on race in private contracts. That was clearly ignored in the South, right? Now, in 1964, we get the Civil Rights Act, one of the most important pieces of legislation in American political history, all right? Now, look at a couple things. Whenever you see it says Title II, Title VII, a title is just some subsection of the Civil Rights Act, all right? Now, look at this. It bans discrimination in places of public accommodation on the basis of race, color, national origin, or religion. Now, this is a case you have to know, right? Heart of Atlanta Hotel versus the United States, all right? So what happened was you had the Civil Rights Act of 1964, and so the Heart of Atlanta Hotel was a hotel in the South that said, we're a private business, no shirts, no shoes, no service. Oh yeah, by the way, no blacks can stay here. So the Civil Rights Act of 1964 banned that, right? So what they do is Heart of Atlanta Hotel challenges the constitutionality of the Civil Rights Act of 1964, right? They say Congress doesn't have the right to do that and their commerce powers. And so in Heart of Atlanta Hotel versus the United States, which is going to be on the test, and I know it's an important case, is the idea that private businesses cannot discriminate on the basis of race. It also said that Congress, the Civil Rights Act was constitutional, meaning that Congress could do that in places of private accommodation. So Heart of Atlanta Hotel says Congress's power to regulate interstate commerce allowed them to say no discrimination in hotels or restaurants or places of public accommodation based on race. Heart of Atlanta Hotel upholds Congress's right to regulate interstate commerce and stop discrimination based on race, right? Heart of Atlanta Hotel upholds that portion, Title II, of the Civil Rights Act of 1964, right? Okay. Now, one of the things about Heart of Atlanta Hotel is on an interstate highway. People traveled through Georgia across the country there, so it was clearly interstate commerce, right? Okay. Now, that denied de jure segregation, legal segregation. There's another segregation called de facto segregation. Even though Congress said, nope, you cannot deny African Americans the right to stop at a hotel room, right, or discriminate on the basis of race, you know there's places in Georgia that African Americans didn't go because they were scared, right? Like it's still, that threat existed, right? That's de facto segregation, that it still exists even though legally it's not okay, which is de jure segregation is ended. Legal segregation was ended, all right? Okay, now Title VII of the Civil Rights Act. No employment discrimination on the basis of race or sex, right? Now the idea here is that you cannot say, I'm not hiring somebody because they're black, right? And in reverse that, you cannot say I'm not hiring someone because they're white. You know, this is our Bakke versus UC Davis, right? This case that says you cannot use quotas. You cannot say race is the primary factor in letting someone into school. What Title VII says is you cannot use race as the primary factor in hiring somebody, right? Now, if you hold all these other variables, and race maybe is one of the many variables, if somebody's all equal, and then race, you know, you end up saying, we want somebody who is more diverse. We want a more diverse workplace. That's probably going to be upheld. All right, but again, remember that affirmative action in the Executive Order 11246 is basically, remember that affirmative action, you cannot, according to Bakke v. Davis, you cannot, according to the Bollinger cases that were in the last set of notes, right? You should look at the Gratz and Grutter v. Bollinger again. You cannot use quotas. You can't say 12% of the country is African American, therefore 12% of the people we let into school, or 12% of the people we hire in this case, are African American. You have to look at people and see, are you qualified? Are you experienced? Are you skilled? And then if you decide, race, then maybe, right? Or economic status, or favorite baseball team, or, you know, some other variable, it will be okay. All right? Now, then a series of legislation, this is all in the 60s, right? The Fair Housing Act. The Civil Rights Act of 1968 is the Fair Housing Act. No covenants had, restricted covenants are unconstitutional. Basically, which means, like, you know, Mr. Faker bought an old house over in Reno, and in the covenants, in the, like, paperwork, there was a thing that said, this house will not be sold to African Americans or Jews, right? Now, that because of the Civil Rights Act, you know, of 1968, that stuff was dead, but it was still, like, in the paper trail of this contract, right? So it didn't mean that Mr. Faker was accountable. It was just, like, an antiquated part of it. But that used to happen. They say, okay, we're not going to sell houses to this demographic or this demographic, right? Stopped in the 1968 Fair Housing Act. And there was an interesting study that somebody did where they sent in a young white couple to buy a house, and this realtor took them to one area, and then they sent a young African-American couple, and the realtor took them to another area, right? They both had the same amount of money. They both wanted the same size house, all that, but that was one of those kind of things that was happening with housing, again, on the sly, on the down low, right? Okay. And then we have age discrimination and the Americans with Disabilities Act, right? This idea that unless age is related to the job performance, right? You cannot say, you're just old and we're creeped out by old people. You know, if you can do the job, they technically cannot deny it because of age, right? Which again means, you know, if you're going to be a bricklayer and have to carry tons of bricks, or if you're going to, you know, do something really, really, really strenuous physically and you're not able to do that because you're older, then they can say you just can't do the job. It's not because you're old. If you're old and strong, good, go for it, right? Okay, and the Americans with Disabilities Act, which is interesting. Now look at this language. Bans job discrimination. It also has that facilities have to be accessible if reasonable accommodations can be made. Now, if it's going to cost your small little mom and shop, you know, $3 million to put in an elevator to get to your level store, something like that, and it'll literally bankrupt your business, that's not reasonable accommodation. But the idea is if you can pour, you know, maybe a wheelchair ramp that's going to cost a little bit, right? They can make you do that because of the Americans with Disabilities Act. You know, the other thing is, like, all federal buildings, all buildings like need to be up to code. If you're built after 1990, they have to be in jive, or they have to be, they have to follow the rules of the Americans with Disabilities Act, right? So these are all kind of private places, all right? That's pretty straightforward, right? Make a cheat sheet of those things, especially that legislation, right? And then go back and study speech, go back and study some things for extra credit, all right? Okay, you guys, have a good day.